Effective as of May 31st, the U.S. Citizenship and Immigration Services has changed the filing location for affirmative asylum applications submitted by mail. They say this change should help streamline the processing and improve adjudication efficiency by digitizing paper filings for asylum. And you should now mail your Form I-589, the application for asylum and for withholding of removal, to the lockbox that has jurisdiction over your place of residence instead of to the service center. Now you go to the Where to File section of the Form I-589 webpage to learn where to file your application. If filing by mail, you should file at the appropriate lockbox location to ensure timely receipt of your application. Applicants who submit a properly filed Form I-589 to a lockbox, they're going to receive two notices. The first notice is going to acknowledge that the lockbox has received and forwarded the asylum application to USCIS, and after USCIS accepts the application, they will issue a standard asylum receipt notice. Both notices will include the same receipt date that is used to determine eligibility for employment authorization based on a pending asylum application and for purposes of the one-year filing deadline. Online filing is also available and encouraged for affirmative asylum applicants who are not in immigration court proceedings and who do not have to submit their application to the Asylum Vetting Center. So a new process for the asylum applications. Asylum seekers say joy over the end of the public health restriction known as Title 42. If you've watched our show for the last 6 years, it's all we've talked about, at least if not on every show, every other show, because it ended on May 11th. However, it is turning into anguish with the uncertainty about how the Biden administration's new asylum rules are going to affect each of them individually. Though the U.S. government opened some new avenues for immigration, the fate of many people is largely left to the United States government's CBP, the Customs and Border Patrol One app, and that is to be used by anyone on the Mexican side of the border who is coming to the southern border of the United States trying to apply for asylum. And you use the government's CBP One app to schedule an appointment at a port of entry. However, a lot of people, including myself, are saying that CBP app is really not fair because it is unable to decipher human suffering, weigh the vulnerability of applicants, weigh how good of a case or how harsh of a reality people are living in right now. And it's just basically by luck if you are able to get an appointment. Now, the Department of Homeland Security said the CBP One app is a key tool in creating a more efficient and orderly system at the border while cutting out unscrupulous smugglers who profit from vulnerable migrants. But since its rollout in January of 2023, the app has been criticized besides for technological problems. It's also been criticized because the demand for appointments has far outstripped the roughly 1,000 appointments available each day. And there does not seem to be an option right now for people to ask for asylum if they don't make an appointment through the CBP app. So it is either the CBP app or nothing. And as a result of all of this, there are, as you can imagine, plenty of lawsuits. The Center for Gender and Refugee Studies is one of the lead plaintiffs, along with the American Civil Liberties Union, challenging some of the new rules in federal court in San Francisco, including the circumvention of lawful pathways rule that requires people to first apply for asylum in a country they crossed on the way to the United States. So that rule really means that unless you're a Mexican citizen, you can't apply for asylum if you crossed over the border without inspection. And this lawsuit is asking the court to allow an asylum request by anyone on United States soil. Texas Republican lawmakers have also sued. Among other things, they argue that the CBP One app encourages illegal immigration by dispensing appointments without properly vetting whether applicants have a legal basis to stay in the United States. Texas is also part of another lawsuit accusing the administration of overstepping its authority by allowing as many as 360,000 people a year from Cuba, Haiti, Nicaragua, and Venezuela to enter the United States under its humanitarian parole authority. But the Biden administration said the new measures, including the app, have helped reduce unlawful immigration by more than 70% since Title 42 ended on May 11th. And the United States government stated that more than 79,000 people were admitted into the United States under the CBP-1 app from its January 12th launch through the end of April. And from May 12th to May 19th, the average of 1,070 people per day presented themselves at the ports of entry after securing an appointment on this CBP app. The administration has also made improvements in recent weeks. According to the Biden administration, the app can prioritize those who have been trying the longest now. And on Wednesday, the Department of Homeland Security officials told CBS News that the Biden administration is expanding the processing of asylum seekers along the U.S.-Mexico border by admitting nearly 40,000 migrants at official crossings each month. And starting this month in June, officials are going to allow more migrants waiting in Mexico to secure an appointment to enter the United States through the CBP-1 government phone app. And DHS officials said U.S. border officials will now distribute 1,250 appointments each day, which is a lot more than the 1,070 up until June 1st. And that's roughly going to be 38,750 appointments each month for asylum at the southern border between Mexico and the United States. And those appointments are going to go to migrants who are waiting in Mexico so they can present themselves at a port of entry for an opportunity to be allowed into the United States and request asylum. Previously, U.S. officials processed just 20,000 asylum seekers each month under the old CBP-1 system. In a statement, DHS said it would evaluate whether to expand port of entry processing even further into the future. The pumpkin is back in the news every day. It doesn't end. We thought he would no longer be president. We get rid of him. Nope, he's just as bad from his pumpkin headquarters in Florida. He's running for president. He's now leading the Republican field. And his number one immigration priority, he says, if he becomes president again, is to remove birthright citizenship. On May 30th, Donald Trump, Mr. Pumpkin, he announced he would seek to end birthright citizenship by executive order on his first day in office. Trump announced his plan on the 125th anniversary of the United States versus Wong Kim Ark, the Supreme Court case that established a constitutional right to birthright citizenship. Now, most experts agree, including myself, I haven't seen an expert who doesn't agree with this, that a United States president has zero authority to end birthright citizenship through an executive order, primarily because the practice is enshrined in the Constitution of the United States, according to the Supreme Court decision, United States versus Wong Kim Ark. And the 14th Amendment grants citizenship to those born or naturalized in the United States and subject to the jurisdiction thereof. And this widely accepted interpretation of that amendment, and that applies to children born in the United States, regardless of parents' immigration status, has been the law since 1898. And the 14th Amendment, for those who don't know, was adopted after the Civil War to guarantee equal rights for former slaves. Immigration restrictionists argued that excludes the children of other groups like undocumented immigrants and its benefits. So the amendment was put into place for to make citizens of former slave citizens and their children citizens. And the Supreme Court said in 1898 it also is to any immigrant who has a child who's born in the United States, no matter of their immigration status. And according to the Trump campaign, the executive orders will explain the clear meaning of the 14th Amendment. Trump disagrees with what the 14th Amendment says. And he says that the children of foreign nationals born in the United States are not subject to the jurisdiction of the United States as defined in the Constitution. And during Trump's term in office, a draft executive order to that effect was previously circulated. The idea was revived shortly after Trump's loss to President Biden, but he never actually signed the executive order. Now, while an executive order altering the interpretation of the 14th Amendment is likely to face legal challenges, its proponents sought to take the case to the courts in hopes of eventually getting a favorable Supreme Court outcome with a 6 out of 9 majority of conservative judges, and also to start the process of having a conversation, a political conversation, a social conversation that's being held in the news by political pundits about what it means to be a United States citizen, and Donald Trump wants to change that. Hopefully, he doesn't become president. Pressure is growing for boycott in Florida including Latino truck drivers, who vowed to stop deliveries across the entire state of Florida. And on June 1st, many Florida businesses shuttered their doors for the day in an immigrant labor strike to protest Governor Ron DeSantis' sweeping new immigration law. The Republican presidential hopeful has railed against U.S. immigration policies and newly arrived asylum seekers for year after year. Florida Senate Bill 1718, which takes effect on July 1st, will offer a preview of the controversial changes DeSantis has said he'd like to see Congress implement if he actually becomes president. Among its provisions, the strict new state legislation in Florida limits social services for undocumented immigrants, allocates millions more tax dollars to expand DeSantis' migrant relocation program, invalidates driver's licenses issued to undocumented people by other states, and requires hospitals to get Medicaid dollars to ask for a patient's immigration status. All of this, by the way, there will be a lawsuit on July 2nd because all of this likely is in violation of the Interstate Commerce Clause of the U.S. Constitution, where each state has to obey the laws of other states in terms of interstate commerce, as well as, so for people who don't know, the Interstate Commerce Clause is what the federal government used to invalidate the Jim Crow laws during the civil rights movement in the 1960s, to say that, for example, you can't discriminate against people because of their color of their skin. It's in violation. Federal government law trumps, I don't hate to say the word Trump, but overcomes the state law because the federal government has a say in interstate commerce, that people who are driving from one state to the other should not be subject to Jim Crow laws under the federal law. So all of this probably, I'm not a constitutional scholar, but probably is also invalid under the Interstate Commerce Clause. So there'll probably be lawsuits about that as well. Going back into the Florida law, there are penalties for businesses and undocumented immigrants alike who violate new employment mandates. All of this will be in lawsuits. Whether or not judges put a stay on enforcing this legislation, we'll see in the end of July, early August. Supporters say it's going to expel the recent influx of immigrants who arrived in Florida and provide more job opportunities to citizens and others in the country lawfully. And critics say it will cost the state billions in lost revenue, while many of the harshest penalties are unlikely to be enforced. Now, if Florida is actually going to enforce all of these laws, this is what it's going to look like. To crack down on businesses hiring undocumented workers, SB 1718 is going to require private employers with 25 or more employees that are making new hires to use E-Verify, the federal online database that employers use to confirm whether someone is eligible to work in the United States. Samuel Santiago, a Florida director of the American Business Immigration Coalition, an advocacy group for immigration reform that benefits businesses, told NPR News that the change will likely have a significant impact on Florida's agriculture, orange groves, construction workers, and the hospitality sectors, industries where immigrants make up a vast majority of workers. And not allowing businesses to be able to utilize these workers will have a really big impact on the economy and the ability to create jobs in Florida. And that's a big problem for Florida, where there's already a widespread labor shortage. The unemployment rate in Florida is just 2.6% in April. So the supporters of this law says that this is going to open up jobs to American workers. What American workers? The unemployment rate is 2.6%. Ask any economist, 2.6% unemployment is full employment. The Florida Policy Institute, a nonprofit policy research group, estimates that without undocumented workers, the state's most labor-intensive industries would lose more than 10% of their workforce and the wages they contribute along with them. That could lead to a drop of $12.6 billion in gross domestic product in Florida in 1 year. That's a loss of more than 1.1% of the entire gross domestic product of the state of Florida, which would in turn cut workers' spending powers, reduce state and local tax revenue. There's been a wave of videos on social media showing images of vacant construction sites, vacant fruit and vegetable fields where harvests remain unpicked, and where fruits and vegetables are rotting. According to the video's narrators, the job sites have been abandoned by people who fear the new bill's e-verify requirements. A graphic on governor's website states that employers who fail to use the e-verify will be fined $1,000 a day. For workers, it will be a felony to use a false ID to get a job. The legislation clarifies that these penalties apply only after an employer fails to use the database 3 or more times within 2 years. And under the new law, a person who transports into Florida someone they know or should have known is an immigrant who has not been inspected by authorities could be charged with felony human smuggling. Now, a person who is found transporting fewer than 5 immigrants on their first offense could be charged with a third-degree felony. They can be sentenced to up to 5 years in prison or pay a fine of $5,000 or both. Now, you may be an American citizen driving your spouse who is undocumented into Florida. That would now be a third-degree felony. The Florida Policy Institute estimates that there are 130,000 U.S. citizens in Florida who are married to undocumented immigrants. That potentially is 130,000 felons. It is conceivable that under the law, a U.S.-born spouse traveling from out of state, as I just said, could be charged with a third-degree felony. Similarly, farm workers who travel together or with family could also be charged. Now, don't freak out. Nobody is arresting anybody for felony for being married to an undocumented alien tomorrow. Somebody eventually will get charged, and there will be a lawsuit, and it will go all the way up to the Supreme Court. And probably all of this will be on hold while this goes through the court system. But it is pretty scary stuff, what's going on in Florida. On May 22nd, a group of Chinese citizens who live, work, and study and raise families in Florida, as well as a real estate brokerage firm in Florida that primarily serves clients of Chinese descent, filed a lawsuit to combat Florida's discriminatory property law, SB 264. This law, signed by Governor DeSantis, the legislation restricts most Chinese citizens and most citizens of Cuba, Venezuela, Syria, Iran, Russia, and North Korea from purchasing homes in the state of Florida. Unless the courts act to reverse this law, it is going to take effect also on July 1st, 2023. The plaintiffs are represented by the American Civil Liberties Union, the ACLU of Florida, the Hang Law Office PC, and the Asian American Legal Defense and Education Fund. The lawsuit argues that SB 264 will codify and expand housing discrimination against people of Asian descent in violation of the Constitution, the Fair Housing Act. It will also cast an undue burden of suspicion on anyone seeking to buy property whose name sounds remotely Asian, Russian, Iranian, Cuban, Venezuelan, or Syrian. Governor DeSantis has argued that this law is necessary to protect Florida from the Chinese Communist Party, but this rationale equates Chinese people with the actions of their government, and there is no evidence of national security harm resulting from someone with Chinese passport owning real estate in Florida. Ashley Gorski, senior staff attorney with the ACLU's National Security Project, said, "Everyone in the United States is entitled to equal protection under our laws, including citizens of other countries. If SB 264 goes into effect, it will profoundly harm our clients and countless other immigrants in Florida." Florida's new law is similar to efforts over the past century to use claims of national security against Asian immigrants and other marginalized communities. In the 1800s and 1900s, a number of states, including Washington and California, had laws known as the alien land laws, barring non-citizens ineligible for citizenship to own real property. The laws targeted Asian immigrants who, as non-whites, were ineligible for naturalization. And these policies not only hurt immigrants financially, but also exacerbated violence and discrimination against the Asian community. Over time, these laws were struck down by the courts or were repealed by state legislatures because they violated the Constitution's equal protection guarantees. Over a dozen state legislatures have recently introduced similar legislation, and many of these bills likewise target people from China. Florida's bill was the first of this wave. Daniel Tilley, the legal director of the ACLU of Florida, said Asian immigrants are part of Florida's fabric. For hundreds of years, they've contributed to our communities and have made this state their home. The discriminatory policies pushed by the DeSantis administration will not go unchecked. According to the State Department data in 2022, consular officers denied a record 220,000 676 student visas. This means 35% or more than 1 in 3 student visa applications were denied, the highest denial rate ever. David Beer of the Cato Institute attributes the change to a shift in the number of Chinese and Indian applications. Chinese visa applications that are granted 2 to 4 times more often than Indian applications are trending downward, which reduces a reliable stream of visa grants. Meanwhile, Indian visa applications are more likely to be denied, and those are going also down. Beer writes, and I'm quoting, "This is a disaster as student visas are the jumping off point for most skilled immigrants. So the impacts will be felt by employers. Immigrants study at America's elite universities and then find jobs when they graduate, largely through the postgraduate employment authorization program called optional practical training. Despite the importance of these student visas, the State Department rejected an unprecedented 35% of student visa applications in 2022. Student visas are known as F1 visas. Student visas usually have a similar rejection rate to other non-immigrant visa applications, but in 2021 and 2022, student visas have been denied at double the rate of all other non-immigrant visa applications. So the student visa denial rate has increased from a low of 15% in 2014 to 35%, which is the highest ever in 2022. It is also consequential for universities. Before a student can even apply for a visa, they must already be accepted into a government-approved university. This means the U.S. Department of State turned down 220,676 students who would have likely paid roughly $30,000 per year or $6.6 billion per year in tuition and living expenses, and spent even more money in the United States. And over 4 years, that number rises to $226.4 billion in lost economic benefits to the USA. The State Department does not separately delineate the reason for student visa denials, but nearly all non-immigrant visa denials are for failing to prove non-immigrant intent. That is, the desire not to move to the United States permanently. Applicants need to show sufficient ties to their home country that would impel them to return to their home country when their reasons for visiting as a student have ended. Consular officers are supposed to only consider someone's present intent, not considering how their intention might change if opportunities arise in the United States. Another ground for denial, which is less frequent but affects many students from China, is a Trump presidential proclamation that bars visas for people who studied at any university that works with the Chinese military on any level. Another reason that may explain the increase in denials is that after major delays during the pandemic, Indian consulates issued an unprecedented 115,115 student visas, by far the highest total for India ever. But according to data obtained by researchers via the Freedom of Information Act request, before the pandemic, U.S. consulates in India are far more likely to deny students than U.S. consulates in China. This means that the surge in processing in India, combined with fewer Chinese applicants, has likely caused a large increase in the worldwide average denial rate for students. Prince Harry is still in the news. A conservative think tank will argue in front of a federal judge on June 6th at the U.S. District Court for the District of Columbia that Prince Harry's U.S. immigration records should be unsealed in light of revelations about drug taking in his recent book. The Heritage Foundation is suing the U.S. government to find out if it acted according to procedure when it granted the Duke of Sussex a U.S. visa. Under U.S. immigration law, evidence of past drug use can be grounds to reject an application if it is considered proof of current drug abuse. The Heritage Foundation filed a complaint under the Freedom of Information Act attempting to compel the government to release Harry's immigration file. An amended complaint filed on May 5th reads, widespread and continuous media coverage has surfaced the question of whether DHS properly admitted the Duke of Sussex in light of the fact that he has publicly admitted to the essential elements of a number of drug offenses. The Heritage Foundation is one of the most influential conservative think tanks in Washington. Niall Gardner, ironically the director of the foundation's Margaret Thatcher Center, Margaret Thatcher being the former Prime Minister of the UK. He tweeted on Thursday that there was a public interest in disclosing Harry's records. He tweeted, quote, "Given his extensive drug use admissions, normally disqualifying for entry into the United States, the American people deserve answers to a very serious question raised by the evidence in Harry's book. Did DHS in fact look the other way?" Harry recently confessed to taking various recreational party drugs in his memoir, Spare, which was published in January. Elsewhere in the autobiography, he disclosed graduating from smoking tobacco to weed during his days at Eton College. And previously, Harry spoke with Oprah Winfrey on how he abused drugs. And past drug use, in my opinion, as a lawyer, I think I know, past drug use does not mean you are a current abuser of drugs. And as long as it was years and years in the past, I think the Duke of Sussex is going to be okay. Yemi Mobolade, a Nigerian immigrant and businessman with no political experience, is going to become the first elected Black mayor of Colorado Springs, Colorado, after he defeated Wayne Williams on the evening of May 16th in the city's runoff contest. Mobolade has received 57% of the vote to Williams' 43%. Mobolade will succeed Mayor John Suthers, a former federal prosecutor and Colorado State Attorney General, who was term limited. Mobolade's decisive victory represents a political earthquake in Colorado Springs, Colorado, which is, by the way, Colorado's second largest city. This is not small little village town. And Colorado Springs, Colorado, long known as a conservative stronghold, yet they voted for Mobolade. Now, Mobolade, he's a married father of three. He moved to Colorado Springs in 2010 and became a leader in the business community. He co-founded two popular restaurants, the Wild Goose Meeting House and Good Neighbors Meeting House, and served as its small business development administrator. He was also the vice president of business retention and expansion for the Colorado Springs Chamber and Economic Development Corporation. Leon Young was Colorado Springs' first Black mayor, though he wasn't elected to the position. Young was elevated to interim mayor in 1997 after the resignation of Mayor Bob Isaac. Mobolade kicked off his victory speech by saying, "Wow, wow, I am speechless." And he closed out his victory speech by announcing that his father passed his U.S. citizenship test just the week before the election. He said, "Greater things are yet to come. Greater things are still to be done for the city." Thanks for watching. For more Brad Show Live, like and subscribe to our YouTube channel.